trial court granting plaintiff leave to amend to state a claim for punitive damages. Your Honors, I've asked to reserve 3 minutes for rebuttal time when I conclude my opening remarks.
Mr. Tobin, could you move the mic just a little closer to you?
Certainly, Your Honor. Is that better?
Yes.
Okay. Thank you, Your Honor. Your Honor, plaintiff sued CNN for defamation concerning news coverage about profiteering in the chaotic days after the United States government withdrew their troops from Afghanistan. The record before this court shows that CNN aired these newsworthy stories after more than 2 weeks reviewing information from sources, including social media posts by Mr. Young, where he was flippant, evasive when people asked him about his pricing model. After 8 days of direct, evasive communications with Mr. Young, where CNN asked him about his pricing model, and he would not respond in any substance.
Well, it seems to me that with regard to the allegations that CNN said Mr. Young's prices were too high, that's kind of a subjective thing, right? You know, whether something costs too much seems like mostly opinion, right?
It is an opinion, Your Honor.
Okay.
An opinion is not actionable.
So the thing in this particular case that does seem a little more actionable was the fact that, you know, when they were talking about Mr. Young, they had his picture on the thing, and there was a chyron that says he was involved in a black market. And, you know, I've looked in a couple of dictionaries, 3 or 4, and the first definition for black market in all the dictionaries is criminal activity. And, you know, if you are accusing someone of criminal activity and they're not involved in a crime, that's usually defamation per se, correct?
Under the law where we would be looking at the defamatory meaning, perhaps it would be. Here we're on a question of actual malice, express malice, and outrageous conduct measured by objective standards. Under that criteria, Your Honor, regardless of what the meaning may be in the dictionary, which is an objective definition, what plaintiff needed to show is that subjectively, CNN intended that meaning. Otherwise, there is no facts in the record to give rise to a reasonable jury question about actual malice.
Tell me how the triad works.
The triad, Your Honor, is a group of 3 different departments at CNN. It's the Standards and Practices Department, it's the Legal Department, and it's the Editorial Department. They come together and
so these are lawyers and professional writers that you know, are used to dealing with words and have dictionaries and know how precise what words mean?
One would presume, Your Honor, that they're educated people, that they've been in the business for a while, but Your Honor, there is nothing in the record discussing the word blackmail at all among any of the CNN journalists.
Yeah.
And it is plaintiff's burden.
Well, black market is the word that was used in the chyron, right?
Actually, Your Honor, the words used in the chyron and said by Jake Tapper when he introduced the story was Afghans trying to get out of the country face a black market full of promises, demands of exorbitant fees, and no guarantees of safety or success. And so, in context, we maintain that it is clear on the face what CNN meant by black market, which is defined within the phrase itself. Market full of promises, demands of exorbitant fees, and no guarantees of safety of success. And there is no dispute, there is no evidence in the record that CNN, for example, knew that promises were being fulfilled or that there was a demand, there was not a demand for exorbitant fees. We just discussed that. That's an opinion, Your Honor. No guarantee of safety or success. The issue under
I hate to keep harping on this, but none of those things describe what could be commonly referred to as black market. I see Judge Roberts' point that black market clearly implies, dictionary definition or otherwise, an illegal exchange of goods.
Your Honor,
that has nothing to do with those other descriptions in the chyron.
If it was a poor choice of words, Your Honor, and at best we argue that it was at best a poor choice of words, Your Honor, that may have impact on the rest of this case below under negligent standard actual malice, I mean, whatever standard the trial judge decides to apply. Here, in the punitive damages context, the burden was the plaintiffs in the court below to show that that is the meaning that they intended. It is not implied, it is not assumed by the court, it is based on record evidence under 768.72 of the intention for that meaning.
So what are we to make of the internal emails that were brought into the record where they called Mr. Young a shitbag, they said that they were going to nail this Zachary Young MFer. Said he had a punchable face, said he was an asshole, and said it was his funeral, bucko. What do we make of those?
Your Honor,
Is that at least some evidence of malice?
It's actually the opposite, Your Honor. It's evidence that the CNN journalists, as they were taking information in, as information was coming in from different sources, sincerely believed that Mr. Young was engaging in exploitive and shady practices. So, for example, at Appendix 408 to 413, in October 17 to 26, almost a month before this story ran, Jill Kornetsky, with whom CNN had already been corresponding, she was another person who was trying to help people through NGOs get out of Afghanistan. She showed CNN Mr. Young's responses to her questions. She said to him, "Tell me about this pricing model where you're charging $75,000 per carload, $14,500 per person. Tell me about your pricing model." He responded, "I don't have to defend our model to some spiteful bitch on LinkedIn. We waste someone else's time." He had a similar response to someone named David Lerner, who Ms. Kornetsky forwarded that exchange to CNN, to Mr. Marquardt, in which Mr. Lerner asked him $75,000 per carload, which is what Mr. Young quoted him, just for transportation? Mr. Young responded, "Just for transportation? You can't be serious. Good luck, David. Have them run for the board themselves and see how far they get." And on October 29, CNN saw an email as well from an Afghan, who Mr. Young quoted a price of $14,500 directly when the man said, "I have no corporate sponsorship." So we know that in the October 17 to 29 timeframe, CNN was receiving all of this information that showed Mr. Young was at best snarky, at worst cruel to people.
Let me make sure I understand something. That last exchange with the Afghan citizen, that shows you that Mr. Young was dealing directly with Afghans. Even somebody specifically asks him, "Can I just pay you myself?" And he says, yes.
He says 14,500
Right.
was his answer. That's at
But
A334.
does that demonstrate that he's actually working directly with Afghans without a sponsor?
I would say a fair reading of that document is that he was quoting a price directly to an Afghan. CNN did not report on that, and I would ask the court to note that even though CNN had that particular email, this goes to actual malice, CNN refrained from reporting that information and went with Mr. Young's interpretation, which was sponsors only. They reported that 3 times in the Jake Tapper, in the segment run on Jake Tapper's show. They didn't report, and they reported it in the text article very prominently, that Mr. Young asked for sponsorship. And so, Your Honor, to get back to Judge Roberts' question, so by the time November 1 comes along, which is at A121, we've seen the text at 332, A332, A334, A138, and A408 through 13, in which Mr. Young engaged with people in a flippant manner who were trying to find help. And at that point, when Mr. Marquardt texted his coworker and said, "We're going to nail this Zachary Young M-fucker," and then noted that he called Ms. Kornetsky a spiteful bitch. Our answer to Your Honor's question is that the pejorative terms, the curses that CNN used, showed that by the time they were receiving this information—
Well, whether Mr. Young had malice towards CNN is not of legal import here. The issue is whether CNN had malice towards Mr. Young.
But what I'm talking about is Mr. Young's language and Mr. Young's attitude formed the impression in CNN that he was a profiteer, that he was doing—
So your argument is his attitude led to the contentious things that were said about each other?
Absolutely, and that's the only thing that the record shows. After all, Mr. Young decided to move for punitive damages before any deposition testimony. So all this court has is the cold record, and in fact, Ms. Shulman urged the trial court to wait on the ruling until there was more evidence in the record. The trial court declined, and here we are. Your Honors, based on the cold record that we have—
Let's go back to what the standard is in 768.72. In subparagraph 1, it says, "In any civil action, no claim for punitive damages shall be permitted." So basically, the trial judge has to sit as a gatekeeper and have an evidentiary hearing unless there is a reasonable showing by evidence in the record or preferred by the claimant which would provide a reasonable basis for recovery of such damages. So So what do you think that standard means, and why do you think that Mr. Young did not provide a reasonable showing by evidence?
Reasonable showing by evidence means that Mr. Young had to show three things to prevail in a case by a news media defendant about a matter of public concern: actual malice, express malice, both subjective standards, his burden to show, and then objectively that the conduct was so outrageous it's the worst of the worst conduct that a Florida court Florida society should not tolerate. That was Mr. Young's burden under the reasonable probability showing. If he could not show that evidence, and he did not, then he has no reasonable probability, no reasonable basis to ask a reasonable jury to fine for punitive damages under the applicable standard in Florida. And so, Your Honor, as to actual malice, we've had the discussion. As to express malice, Mr. Young did not show that the primary motive for CNN in reporting on this story, after all, it was a 5-minute story, 2 minutes of which were about Mr. Young, and there was a lot of other information in there in a time frame when a lot of Americans—
But there were no other individuals that were highlighted as providing these overpriced black market activities.
That's correct, Your Honor. I merely pointed out to discuss what the record reflects as to CNN's motive, and it does not reflect a primary motive to do this story, to call Mr. Young anything other than somebody engaged in activities in a chaotic environment in Afghanistan, which was a matter not only of public interest, but the U.S. government's interest, the non-governmental organization's interest, and the interest of all Americans who were trying to sort out the U.S. government's conduct in withdrawing the troops from Afghanistan. And so, Your Honor, those were the three standards that Mr. Young had to meet. He did not meet actual malice. As we've discussed, if anything, the evidence shows CNN sincerely believed what it was reporting. He did not show that it was the primary motive of CNN to get him, which is what the case law strictly requires. And I'll be happy to discuss outrage if I have an opportunity when I come back for rebuttal.
All right. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court. My name is Vel Friedman, and I represent plaintiff Mr. Young in this appeal. Your Honors, Mr. Young was a U.S. Navy veteran and a former U.S. government operative that worked for the United States abroad for many, many years. When he retired, he went to the private practice, began doing security consulting until in 2021, the U.S. government pulled out of Afghanistan and people started needing evacuations. Mr. Young was able to leverage his network of people and experience, very unique experience, to help successfully evacuate 24 children and women from Afghanistan on behalf of major corporations like Bloomberg, Audible, subsidiary of
So
Amazon.
where do we have that as part of the record? Do we have evidence of that?
That's all. Do you have evidence of that? This is in the amended complaint. I don't really believe it's disputed, but it's not necessary for my argument. It's just a bit of background. I'm happy
Okay.
to move on if that's helpful. CNN finds out about Mr. Young's work. It's not in dispute that he was evacuating people out of Afghanistan, and they set out on a path to take him down, or to quote the words of Alexander Marquardt, the main reporter on the case, to, quote, nail that Zachary Young MFer. And so CNN puts together what their own breaking news editor, Megan Trimble, calls—
Well, I mean, yeah, don't you agree that whether Mr. Young's prices were reasonable under the circumstances is kind of just a matter of opinion?
I don't think the reasonableness of his prices are being sued over. I think there are two bases that are the general, that are the bases for the defamation lawsuit. The first is, as the court has noted, as Judge Roberts, as you noted, is the black market definition. And Judge, I would add that the black market has one definition in every dictionary not just the first, but one in every dictionary we've looked at. And CNN has failed to put forward any dictionary with an alternative definition. It means illegal activity. Full stop. And that's what the case law that we've quoted to the court as well treats it illegal activity. So that's one basis. The second basis isn't about the amount of money he was charging. It's that he charged—
But do we need to look at their intent? Because opposing counsel's argument was that they were using it in a more colloquial sense. They weren't saying this man's committing a crime. They're saying this man's doing something shady.
So, Judge, I think it is absurd in its face to say that they are using the word black market that has but one definition in the English language in a way that it wasn't intended to be used. So what CNN is claiming is they took a word from the English language that has one definition, and they meant, when they said black market, they actually meant gray market. But they said black market that has one definition. CNN can't get up there and say, hey, Mr. Young is a serial killer, but actually mean that he was a good Samaritan, but they only knew that in their head. And you know what, Judge? If they did, fine. Let them argue that to the jury. At this stage, as the court was focusing on appropriately before, we need to show a reasonable showing that a reasonable basis for punitive damages exists. Will a jury buy that argument that they meant something else when they said black market? I don't think so. But this court is only serving in a gatekeeping function at this point to ensure that proper claims of punitive damages reach the jury. And to say that when somebody uses a word that means what it means is not a sufficient showing, then I don't know what should reach the jury for punitive damages claims. And Judge, that's really important. You really need to focus on the standard that applies in this case, because there are three overarching standards that apply. The first is that plaintiffs have to make a reasonable showing of a reasonable basis, that a reasonable basis exists for a jury to find that CNN purposely or recklessly defamed Mr. Young. But that's not all. And I want to point out, not a perfect showing and not a perfect basis. Reasonable showing, reasonable basis.
So your argument is that sub 2 of 768.72, where it says that the trial fact based on clear and convincing evidence, that's not here.
Correct, and in fact, we filed a notice.
That's the jury's charge.
That's the jury's charge, and we filed a notice of supplemental authority yesterday with the court from a decision from the third DCA that came out in late March, which had that expressed finding, which is, at this point, clear and convincing evidence is not required. It's an express finding from the third DCA. So we just need to show the reasonable basis, reasonable showing a reasonable basis. Now, to win, we need to show clear and convincing evidence, but that's not what's before the court today.
Well, you would agree that it's not like a typical cause of action standard where we're required to accept your allegations as true for the purpose of the amendment, that reasonable showing by evidence means something more than that, I presume.
It does, Judge, and that folds into the two other standards that I said were overarching, right? So when you look at the proffer, right, it's not an allegation like on a motion to dismiss or just now. It needs to be evidence, and evidence was put forward. The fact is, we didn't need to wait for deposition testimony because the evidence in this case is overwhelming and put before the court. So when you look at whether a reasonable basis of a reasonable showing of a reasonable basis occurred, you must look at the case, you must look at the evidence presented, in the light most favorable to the plaintiff. And that's the 701 Palafox decision from this court, that the evidence is viewed in the light most favorable to Mr. Young. And when looking at the evidence, it's not viewed in isolation. You look at the totality of the circumstances.
So I was on Palafox. I don't, and I don't think we answered this question about the relationship between the reasonable showing and clear and convincing evidence.
You did not.
Do you think to resolve this case, we need to wade into that and answer that question here?
I don't think so, Judge.
So like the fourth certifies a question on that very issue, right? In Perlmutter, do you think that we need to go all the way there?
I don't think so, Judge, because I think the language of the statute is very clear that it needs to be a reasonable showing, reasonable basis. Even if the court were to fold in that has to be a reasonable basis of clear and convincing evidence that a jury could eventually find, that information is before the court right now. So even if we were being held to a clear and convincing standard, there's still sufficient evidence in the record to show that we've met that burden. And so I think the court can sidestep that issue entirely. In fact, there's a couple of issues CNN raises that I think the court doesn't need to resolve. Another issue is, does the court have to weigh competing evidence in this case? Doesn't matter. Court doesn't need to resolve that question here because even when taking all of CNN's evidence into account, when viewed in the light most favorable to Mr. Young, it is very clear here that Mr. Young has satisfied the burden imposed by the statute. So if I turn to some of that evidence, there are essentially three buckets of categories of evidence that were put before the trial court. One is that the facts that CNN knew, and those facts undermine any suggestion that Mr. Young was involved in any kind of illegal activity. The second category is CNN's internal documents. They demonstrate that CNN held significant bias, ill will, and an agenda against Mr. Young. And the third is CNN's reporting itself, which, as I'll demonstrate in a minute, was so reckless, shoddy, and agenda-driven that its own editors were in full revolt that CNN was publishing these stories. So going to the first category of illegality, number one.
I'm concerned about that because, I'm sure that there are editorial disagreements in news organizations all the time. And I'm wondering how much we should use those disagreements as evidence of malice or reckless disregard. Because I'm sure on a lot of stories, there's internal debate. And there's someone that has to make the decision based on hearing everybody out, and I don't know if that's evidence of malice or ill will or any of that.
Well, Judge, I would suggest that the evidence in this particular case goes beyond mere disagreement. I'll highlight that in a minute. But again, that brings me back to the idea that is undisputed. This is a totality of the circumstances review. So it could be that the editor's comments standing on their own are insufficient to get us to malice. But you've got to fold that
And
into.
can you try to stay central behind the mic?
I'm sorry.
Because this is being recorded.
I will
People
hold
are-
on tight.
People are good. You can move some, but if you get too far away, they're not going to be able to hear
Understood, Judge.
you.
I'm sorry. So this is a totality of circumstances. So fold that into the terrible, statement CNN made that show that they're going to nail the Zachary Young MFer, that they are, that he's a shit, an a-hole, and some of the other terrible statements, like it's your funeral, bucko. Fold that into the divergence from journalistic standards, taking from a clearly biased source and running with an agenda. Remember, my learned adversary here talked about a woman that Mr. Young called a, quote, spiteful bitch. Well, she was the source of this entire story. And at the end of that exchange, once the story was published, Mr. Marquardt sent the story to her and said, probably not as bad about Young as you had hoped, right? I mean, this was a clear agenda-driven story. So my answer to your question, Judge Roberts, is maybe on its own it's not enough, but look at the totality of the circumstances. Stepping back, on its own it's enough. This is not mere disagreement. The editors called it a, quote, infernal story that was, quote, pretty flawed and, quote, very much not ready
Well,
for
it certainly
prime time.
sounds like all these people got off on the wrong foot, but, the fact that there was a level of contention and there were unfortunate things said on both sides. How much of that can we use to say that CNN didn't follow their journalistic duty?
Well, those are two separate questions. The nasty emails from CNN go to showing that they intended to harm Mr. Young. And I don't see how you can come to any other conclusion from the statement, we're going to nail that Zachary Young MFer. What a punchable face. It's your funeral, bucko. When he said, I'm going to nail this Zachary Young MFer, the response was, going to hold you to that, cowboy. What a shitbag. What an asshole. He's a shit. Triad, one of the members of Triad, CNN's senior executive committee, said, yeah, he's a shit. So this doesn't go to their diversion from journalistic practices. It goes to malice. They wanted to harm him. They wanted to hurt him with this story. What goes to the diversion of journalistic standards is the rush to publication. They gave Mr. Young 2 hours. Yes, they talked to him for a week, never telling him they were going to publish a story about him. The first time they say, we're publishing a story about you, they give him 2 hours to comment. Mr. Young says, you're wrong, and that's not enough time for me to comment. And what's CNN's response? Mr. Marquardt texts a colleague, effing Young just texted. But even though he says effing Young just texted, he doesn't delay
So
publication.
do we know in the record when Mr. Young became aware that he was talking to CNN?
He knew he was talking to CNN earlier, but they were told him they were trying to gather information about like the evacuations in general. They didn't tell him they're running a story on
Well,
him.
CNN is in the business of running stories. Why did does he think that he just called him because they think he's a good guy or wanted to get to know him?
Well, CNN does background research all the time. If you go into the discovery, even the evidence in this case, CNN talked to many people they didn't end up quoting. In fact, while they spoke to many different people, Mr. Young is the only person in the entire story that is mentioned and whose face is on the television and his name is on television with the accusation of black markets right underneath it. So I think, Judge Roberts, in fairness, just because CNN reaches out for information doesn't mean they're running a story about you. And the moment they tell you they're running a story about you, they give him 2 hours to comment. He says it's not enough time. And by the way, CNN's own internal people thought that wasn't enough time. There's this internal correspondence in the record. I hear it's airing tomorrow. Seems early. Answer, airing in 2 hours. Response, well, shit. So CNN itself knew 2 hours was not insufficient amount of time to let the story run.
Well,
And so-
one employee of CNN thought that that was insufficient.
Fair enough, Judge, but again, reasonable showing of a reasonable basis that there was malice, departure from journalistic standards. This court isn't supposed to be the ultimate trier of fact on whether or not CNN is subject to punitive damages. That's the jury's province. This court is supposed to act in a gatekeeping function to make sure meritorious claims meet the jury and to winnow out the bad claims. This is not a bad claim, right? CNN has no evidence that they thought Mr. Young was engaged in illegal activity. There's significant evidence that he was not engaged in illegal activity. There is proffered evidence to the trial court that CNN was trying to harm Young and hated him. There was evidence proffered that the work on the case was so shoddy and agenda-driven that many of the internal editors were uncomfortable with the story going forward. There was proffered evidence that CNN departed from basic journalistic standards, rushed to publish, ignored warnings from Mr. Young, relied on a biased source. How can it be that this isn't a reasonable showing of a reasonable basis to find that malice occurred here and that CNN, at a minimum, recklessly published the story? And if this court finds that this isn't enough, I don't know what case is. Is the court requiring a private journal from Mr. Marker where he says, I really hate this guy, Mr. Young, and I think I'm going to write a story for the sole purpose of harming him? I mean, there's plenty of case law we cited to the court that says people don't advertise their defamations in advance. You're almost never going to find that smoking gun admission of internal intent. What we have to do is show a basis that the jury can say, you know what? This is malice. This is recklessness. This is purposeful attempt to harm. And we've shown that. Through all the evidence that's come through, we've proffered sufficient evidence to make a reasonable showing that there was a reasonable basis for a jury to find. CNN, at a minimum, recklessly published this material. The only other thing I want to touch on is this idea of that black markets subjectively meant something else. Again, we touched on this, but CNN cites a bunch of authorities for the proposition that that's not enough. And the way I want to push back on that is if you take a look at these authorities, all of those authorities were statements where the alleged defamatory statement was ambiguous or was defamatory by omission. And there's a huge distinction between those where you have an ambiguous, like a metaphor, where the sound is wandering around the room, and so you need more, and our case where they use the term black market that has, again, but a single dictionary definition in the English language. Unless the court has questions, I see I'm over my time.
Thank you.
Thank you, Your Honor.
May it please the court. Your Honor, Judge Long, to your question about the clear and convincing evidence standard, it's not been adopted in the first DCA as binding on this question, motion for leave to amend. It has been adopted in Federal Insurance Company versus Perlmutter in the fourth DCA. In this instance, it is required, regardless of the statutory construction, for actual malice, because actual malice must be shown in any inquiry by clear and convincing evidence. We get that from New York Times v. Sullivan. We get that from Mile Marker versus Peterson Publishing Company in the fourth DCA and the Don King's Productions case in the fourth DCA. So to make a reasonable showing to a jury, he had to have proffered sufficient evidence to meet the clear and convincing standard of actual malice. I think it's an open question, to be honest, about the express malice and the outrage part of the calculus, but as to actual malice, that is required, that is his burden. And as to the word black market, there is nothing in the record discussing what CNN was thinking, what they were saying to each other, what their intent was. There is an absence of any evidence in the record, and because it's such a high burden, because it is his burden, such a high standard, it can't be assumed, it can't be applied, it has to be shown by record evidence, and plaintiff simply has shown none whatsoever. As far as the words exchanged among the journalists themselves to describe Mr. Young, we talked about that. I just wanted to point to the court language in Nodar versus Galbraith from the Florida Supreme Court that specifically says strong, angry, or intemperate words do not alone show express malice. And so I think there's a recognition in the courts that if people express themselves in certain ways about the plaintiff, there are no inferences to be drawn if that's the evidence that they're pointing to, and they rely very, very heavily on that
Well, does that
evidence.
mean there's no inferences? That you can't draw a reasonable inference? Or does that just mean that it's
You
maybe
could.
not enough alone?
If the email said, I know this guy, I've been watching him for years, we're friends, he didn't pick my daughter up at daycare on time, he's a shitbag, I'm gonna run a story on CNN and get him. That would be great evidence of express malice, of a primary motive or intent to harm, which is the standard, primary motive, not secondary, not tertiary, primary motive. That's not what we have here. We have, as I recited before to Judge Roberts' question, we have a series of information, pieces of information coming into CNN from which they were reacting and forming an impression, and that's the opposite of actual malice. That's conviction, clear conviction in the gist of that portion of the story that Mr. Young was a profiteer. Your Honors, Your Honor, you brought up, or he brought up and you reacted on the Palafox case. I think the Palafox case is an excellent illustration of what you do with plaintiff's evidence. You look at it, you accept, or you read what he proffers to you. In the Palafox case, it was the engineering report that talked about one type of equipment, one type of property, and then you look at the other evidence that's put into the record. And in Palafox, they looked at the two different sets of issues, the engineering report and the equipment was used elsewhere for a different purpose. And you held correctly that that was not evidence, that report was not evidence of the high standard needed for punitive damages. And we are talking about a very high standard here. It must be so outrageous that society can't tolerate it. Yesterday, he cited to the court a drunk driving case, which the Florida Supreme Court has said per se is intolerable for good and valid reason. But it also notes and reinforces that it has to be as high as the standard of criminal manslaughter, the conduct. And the journalism that CNN published in the public interest to talk about war profiteering in Afghanistan during the time period when many people thought that the U.S. government had precipitated a chaotic and dangerous environment is not committing criminal manslaughter, is reporting journalism in the public interest and should not be subject to punitive damages. Thank you, Your Honor.
Counsel, I thank you both for your argument. It was very enlightening and well-crafted. We're going to take a 10-minute recess to allow counsels to shift, and we are in recess.
All rise.